Welcome, everybody, to today's webinar. Today, we are talking about caring for a loved one with dementia. We have an amazing guest speaker with us today, Jeremy Bobot, who I will introduce to you in just a few minutes. My name is Paula Price. I am with the People's Law School, and I will be your host and moderator for today's webinar. You know that you are in the right place if you're here to learn more about caring for a loved one with dementia. And the content for today's webinar is based on questions that we received from guests who have attended previous webinars or who have written into the People's Law School website. So what you can expect in terms of the nature of questions, we'll be talking about whether a person with dementia has capacity to make a will or sign a power of attorney. We'll be talking about what powers you may have under a power of attorney. And another topic we'll cover is what to do if you and your siblings disagree about how best to care for your loved one. Now, what you can expect today, we have 60 minutes together, and you'll receive answers to your questions in the form of legal information, not advice. If what you're seeking is the law as it applies to your unique set of circumstances, we encourage you to reach out to a lawyer. You're welcome to reach out to our speaker, Jeremy. His contact information is on the slide, or you're welcome to reach out to another lawyer, of course. The information that we are sharing is current as of today's date. And we would like to acknowledge that we are grateful to work on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations, whose peoples continue to live on and care for these lands. We encourage everybody who has joined us here today to also reflect on where it is that they are joining us from. We'd also like to thank our funders, the Department of Justice Canada, the Law Foundation of BC, and the Notary Foundation, whose financial support makes it possible for us to produce these webinars. And finally, last but not least, we would like to welcome and thank our speaker, Jeremy Bobot. Jeremy is a barrister and solicitor and a notary based in Vancouver, BC, and he has over 20 years of experience in practice. He runs a community-based law practice where he helps people like you with wills and estates, among other areas. Now, the work he does in wills and estates includes estate planning. So that would include preparing wills, powers of attorney, representation agreements, and advance directives. It also includes assisting executors with the process of probating wills, transmitting estate property to beneficiaries, and preparing estate accounts, and estate litigation. So that would be such as when a will needs to be cured, revoked, or defended. And not only does Jeremy have the substantive knowledge to share with you today, he's also very personable and relatable and makes the law make sense. So we're absolutely thrilled to have Jeremy be our speaker today. Welcome, Jeremy.
Thank you, Paula. Thank you for having me. It's my
Well,
pleasure.
we're excited to have you. So with that, we're going to jump into the questions for today's webinar, starting with this question. Um, my mother has early onset Alzheimer's and lives in a care home. She can speak and is generally lucid, but she wouldn't remember enough to pass a cognitive test. Would she have capacity to sign a power of attorney?
Okay. Well, hello, everybody. Nice to meet everybody through Zoom. Um, in terms of just getting into this question, there's a few issues to be brought up. Early onset Alzheimer's would suggest that she's probably going in and out of lucidity, which means that there are going to be moments when she understands what's going on, she understands her property and her obligations, and there are going to be times when she's out of touch with her property and her obligations and a reasonable way to manage her property. So in a situation like this, when we say that she doesn't have enough memory to pass a cognitive test, I'm not exactly sure what cognitive test that is, but there isn't one standard test that applies when it comes to ascertaining capacity for a power of attorney, for example. There are all kinds of medical tests out there, like the mini mental exam, the MME test. Lawyers are meant to satisfy themselves that somebody has the capacity, for example, to enter into a power of attorney. And my approach to the situation is very specific to the client and their situation. So, for example, if people bring in their elderly mother or father to me to make a power of attorney, and the parent is willing to appoint all their children as attorneys, then the test to pass would be much lower, meaning that she could have much more challenged capacity. But I know that all of her loved ones, all the ones that would be the natural beneficiaries of her estate, are all going to be involved in caring for her and managing her property. So it's a much lower standard that she would have to pass. If, for example, only one of two children is bringing in their elderly parent to make a power of attorney, and that child says to me, well, my mom isn't close to my sibling and they're not usually involved in helping to care for my mom. So, no, my mom doesn't want to appoint them as a power of attorney. That requires a much higher standard of capacity, in my opinion, to make sure that, in this case, the elderly parent understands they're going to be empowering only one of their children at the expense of the other. And of course, it's impossible for me to get a full history of the dynamics with those children and is any of the children up to foul play. So, my advice would be that if you have a parent with early onset Alzheimer's or dementia, they're beginning to become forgetful, they're not really making sense anymore. Maybe they're writing out checks but forgetting to sign them, or they're dating them, with a date that was 20 years ago. Um, that would be the time to bring them to a lawyer, have them ascertained for their capacity. And again, if all their children are available to act as a power of attorney, then in my opinion, I think that would be a lower standard that you would have to meet in order to be able to sign a power of attorney.
Excellent. Thank you so much, Jeremy. This next question is, my father has dementia. He made a will, but it doesn't appoint an executor. He has not made a power of attorney. How can I manage his bank account to ensure his long-term care fees, medication, etc. are paid?
Okay, so there's a few different issues here. One is that you have a will without an executor. This is quite common. People make wills, 20, 30 years ago, and there's no need to update a will unless you need to make changes to your will. I probated wills signed in the 1950s, and there's no problem with that. But what happens, of course, is that people end up not updating their will and their executors predecease them. So that is not a problem in the sense that it doesn't invalidate the will whatsoever. You can still probate a will where all the named executors have either predeceased or they've all renounced. It just means that somebody has to step forward to become the administrator of the will. It's the same thing as an executor. They have all the same powers, but they're going to be called the administrator. And the law, which is called the Wills and Estates Succession Act, all of BC's estate laws have now coalesced into one law called the Wills and Estates Succession Act, or WESA for short. WESA provides an order of priority for people to apply to become the administrator of the estate. So a spouse, then children, then beneficiaries under the will, and then somebody nominated by a majority of the beneficiaries under the will. And then ultimately it could be anybody out there, but they have to be approved by a court. So the fact that somebody, if you have an elderly parent who's past the point of being able to change their will because they have dementia, and the named executors in their will have predeceased, do not worry about it. Do not stress about it. When the time comes, you or somebody else will simply come forward to become the administrator of that will, and you'll still have all the powers of an executor. So that's just one part of the answer. The other thing, he hasn't made a power of attorney. So if somebody has passed the point of being able to enter into a power of attorney because let's say they'll meet with me and they are willing to appoint all their children, but they simply have no capacity to understand what a power of attorney is, the nature of the document, the consequences of signing it. At that point, it's too late to make a power of attorney. So when it comes to bank accounts, banks will have in-house powers of attorney that allow third parties to manage somebody's bank accounts and pay bills and all that. So you could try bringing your parent to the bank itself to see if they're willing to do an in-house power of attorney. But for other things, medications and other things outside of the bank account, If you find yourselves in a situation where you have an elderly parent that they've passed the point that a lawyer is willing to make a power of attorney for them, and you need to start taking control of their finances or anything else, we need to apply to court for you to be named their committee. Essentially, a judge is going to grant power of attorney to the applicant. It involves a court application. It's going to be infinitely more expensive than just making a power of attorney, but it will provide you with the solution you're looking for. We would have to prove their lack of capacity with medical reports. There would have to be everybody who has an interest in the estate would have to sign an affidavit supporting your application. And when all that's in place, the judge will grant the committeeship. And I guess one last thing I should say is that, well, what happens if you don't apply for the committee? So we have an elderly parent with dementia. They're no longer able to manage their finances, and nobody has authority over their legal and financial affairs. At that point, the public guardian and trustee takes over. So ultimately, the government takes over when we haven't gotten our affairs in order, so to speak. The PGT will pay their bills, they'll take control of all their finances, they'll manage everything until the day they pass. But just for those of you out there who are aware, the PGT fees are very, very, very expensive. The government essentially doesn't want to fully subsidize people who haven't gotten around to taking care of organizing their estate planning, so to speak. So the PGT fees are charged on the size of the estate, and it can be quite considerable, especially if somebody lives for many years.
Excellent. Thank you so much, Jeremy. That's really, really helpful information. Moving on to the next question, and I'll read this one out. It's a bit of a longer question. My friend suffers from dementia and cannot make decisions anymore. She lives in a care home and has no living relatives. I am the power of attorney and sole executor and beneficiary of her will. I'm 83 years old and concerned that my friend will outlive me. Is there a way of legally empowering someone else to act as the power of attorney?
Okay, good question. No, you cannot delegate the authority under a power of attorney unless the power of attorney document explicitly allows it, which can be done, and I've done it countless times, but it's not something that's done by rule of thumb. It's not done automatically. Most people don't want to put themselves in a situation where it might be some stranger third party that's caring for them at a time that they've lost capacity. So most POAs do not include the power to delegate that authority to somebody else. Um, so, um, so yeah, if this person would have to continue acting as POA for as long as they're able to, and if it got to the point where they wanted to resign because they themselves just can't handle the responsibility anymore, or if they passed away, the options would be that somebody would have to apply to become committee of the elderly person with dementia, or the public guardian trustee would take over and care for them.
Excellent.
Yeah.
Thank you so much, Jeremy. This next question is, my spouse has dementia and we own our home as joint tenants. Is it legal for me to sell the property? What powers would I have under an enduring power of attorney?
So this is also a common question to get with clients, that people assume that because they're married or in common law, there's no legal difference between being in a common law relationship and being in a legal marriage. People often assume that because they're legally married or they're on title as joint tenants, that they can act for each other, that it just takes one person to give instructions to close down the account or sell the property. And that's not true. You cannot sign on each other's behalf when you jointly own property. You need the power of attorney for it. Even if you're legally married, it doesn't make any difference. You need the power of attorney. So if you own property with somebody else, a spouse, let's say, as joint tenants, if you don't have a power of attorney, you will not be able to sell the property, refinance the property. There'll be concerns even about vacancy declarations because everybody has to file their own vacancy declaration. So in a case like that, you would need a power of attorney to be able to sign on your spouse's behalf to be able to sell the property, refinance the property. And if your spouse has dementia and it's at a stage, again, dementia being something that exists on a spectrum. So just saying somebody has dementia does not mean that they're prohibited from entering into a power of attorney. Again, it depends on the circumstances, and it's worth seeing a lawyer or a notary to see if it's possible to get that enduring power of attorney. And if they can, then great, you'll be able to do everything you need to do. And if you can't get it, then I would consider at that point applying to court for a committeeship.
Excellent. Thank you so much. So moving on to our next question. My mom has dementia and lives in a care home. I deal with everything for her. My mom and I share a bank account. Do I have to show my sister that account?
Okay, also a very interesting question, and it brings up quite a few legal issues. Um, So I'm going to assume that the parents will often add adult children to their bank accounts and sometimes even to their property in an effort to avoid probate. They figure they're doing advanced estate planning and they're so clever and they've avoided probate. The law doesn't work that way. The law makes it clear that when an adult child is added onto title to a bank account or a property, unless there's evidence that that parent intended to gift that asset to that child, exclusive of any other children, um, then that child is deemed to be holding that asset in trust for the estate. And they're required to include it in the probate application and pay the probate fees on it and then disperse it to all the beneficiaries of the mom in this case. So if and the evidence that the law requires to show that this is meant to be a bona fide gift is usually a gift letter with the benefit of independent legal advice. It's not going to be enough to go to the bank and have your mom communicate to the branch manager, yes, yes, I want my daughter to be on this account. It's going to be her account. That's not going to stand up in court. The gold standard is a gift letter uh, signed with the benefit of independent legal advice so that the lawyer can ensure that the mom understood the consequences of this, meaning that the benefit is going to go to that one daughter to the expense of any other children that they have. So, in the event that the child was added onto the bank account for convenience purposes to pay bills or to avoid probate, they're holding that account in trust for the estate, which technically means that, yes, they should show their sister that account just for full disclosure purposes. And really, that any expenses paid from that account should be for the benefit of the parent. It's not meant to be a free for all for the children in a case like that, unless, of course, there is a gift letter, in which case that daughter is that daughter's personal property, and she can do whatever she wants with it. But that's hardly ever the case.
Excellent. Thank you so much. Um, Moving on to our next question. My mom has dementia. Before she lost capacity, she named both my sister and me as powers of attorney. I don't have a copy of the power of attorney. My sister has been representing herself as the sole power of attorney. What can I do to prove that I have power of attorney?
Okay, so once again, there's a few different issues in this. I'm assuming from the question that the other sister who's representing herself as having sole POA has a signed copy of the POA. I can tell you that an unsigned copy of a POA is worth nothing. No bank is going to accept it. No lawyer is going to accept it. It really isn't worth anything. You need a signed copy, and it really should be the original POA or a certified copy of the original POA. A photocopy of a signed POA will also not really have any value. So presumably in this case, the sister is holding out a signed copy of the POA. POAs, when they name two people, can do so in two different ways. They could name both people and say that they have to act together for everything, or it could say that either one can act alone. So in this case, the POA says that either one of them can act alone, then the sister may represent herself as sole POA, but the POA document itself will make it clear that they're both POAs and they're both authorized to act independently of each other. So in a case like this, I would suggest to the sister, if she were to come by and with this question, I would simply write a letter to the sister demanding that she give us a certified copy of the original signed POA. And if she refused to do so, we would have to go to court and get an order directing her to give us a copy of the POA and assess costs against the sister for doing that because she was acting unreasonably. Remember that as a POA, this is a fiduciary responsibility, and everything that we do for the benefit of our parent, of the person who granted the POA. So for the sister who has the POA to refuse to provide a legal copy of that POA to her sister who doesn't have the signed copy, there's no possible way that's in their parents' best interest. So they could get assessed with costs if they refuse to cooperate in that capacity. One side note about this is that it often happens that when there are multiple people under a POA and either of them can act separately, that they don't necessarily agree on all the courses of action, be it how to manage investments or what to do for their aging parents. And there's no inherent dispute resolution mechanism within a POA when there are multiple POAs. The hope is that they just get together and act reasonably and come to terms for the benefit of their parent. So, if these sisters are not able to get along, that could create problems for which there's no obvious solution. But without question, the sister with the signed POA should be able to give her other sister a certified copy of that signed POA.
Great. Thank you so much, Jeremy. So for anybody who's entering into that situation, then would the preventative step to take be then to obtain an original, well, have the original and then a certified copy made at the same time so that each of the designated powers of attorney has their own unique document, or how would you normally recommend dealing with that?
I mean, I'm sure that there are going to be times when, if you were to bring a certified copy of a POA to a bank, that they would say, well, that's fine, but we need to see the original. In which case, the sister should be able to say to the other sister, I need the original, and then I'll return it to you. But you should be able to do everything that you need to do with an original certified copy of the POA, because a lawyer or a notary will not make a certified copy of the POA unless they see the original. So banks and the government and the land title office should be able to rely on that lawyer and notary as evidence that there was an original POA and this is a true and correct copy of it.
Excellent. Thank you, Jeremy. This next question, I'm worried that my elderly father is being taken advantage of by his financial advisor. What can I do?
Yeah, good question. So, if, okay, let's start on the assumption that this person doesn't have POA over their father. He's just concerned that his father's being taken advantage of. If he were to call the financial advisor, I would expect the financial advisor to say, this is confidential information. I cannot release any information to you. I sometimes get emails from children of clients of mine to say, my father made a will. He hasn't given me a copy. Can you send me a copy of it? And I have to write back to say, I can't. It's lawyer-client privilege. Unless your father authorizes me to do that, I can't do that. So I would expect the financial advisor to say, unless your father authorizes me to discuss his finances with you, I cannot release any information. So you could ask your father to simply provide that authorization, that consent. If you do have a power of attorney, then you are able to access those accounts. And what you would do is ask for a full accounting from the financial advisor. You would see all the investments being made, all the fees being charged, and so on. And review it. And if you need to, hire a bookkeeper, another financial advisor, an accountant to review everything and make sure that everything is being done properly. It's another example of the importance of having a power of attorney.
Excellent. Thank you so much. Moving on to our next question. My mother is in the hospital and has advanced dementia. She gave both my brothers and me powers of attorney. My brother has been using her credit card to pay for alcohol, lottery tickets, and other things unrelated to my mother's care. What can I do?
So this is a very common scenario. The tragedy of it is that as important as power of attorneys are, there's a tremendous amount of abuse, misuse, and fraud involving powers of attorney. People have direct access to people's bank accounts at a time that they lack the capacity to monitor them. And there's nobody that can look over your shoulder if you have a power of attorney to see what you're actually doing, even family members. And it is possible to apply to court for an order directing the power of attorney to provide a full accounting of what they're doing, but you would need evidence of financial mismanagement or abuse. Really, the only remedy available to to question somebody's actions under a power of attorney is to file a complaint with the public guardian and trustee. They have the mandate to investigate a power of attorney, to ask for documents, to ask questions, and to determine if somebody's acting inappropriately under the power of attorney. So, in a case like this, where somebody has advanced dementia, there's no way that they can even revoke the power of attorney. And one attorney cannot cancel out another attorney just because they want to. So in a case like this, I would suggest to this person that they report the brother to the public guardian and trustee and provide evidence, bank statements, and so on to show that he's abusing the power of attorney. They will investigate. They'll ask him for an explanation, and if he doesn't have an explanation, then steps will probably be taken to remove him as power of attorney.
Excellent. Thank you so
Yeah.
much. Um, Another question involving power of attorney. My friend with dementia has made me her power of attorney. Her adult son lives with her and has been stealing money. I fear he may also be abusing her. As power of attorney, can I have the son legally removed from the house?
So again, this is a fairly common scenario. People just get greedy, I guess, under these situations. Um, So, if there's ever a suspicion of abuse of an elderly person with or without dementia, there are lots of resources out there for you to take action with. One is the Vancouver Police Department has an elder abuse department. There's a hotline, and lawyers are actually encouraged to refer suspicions of elder abuse to this VPD hotline. And I personally never had to do that, but my colleague in my office right next door has had to do that. Sometimes we have people bringing in a child, bringing in the parent, forcing them to make a will, leaving everything to them at the expense of their siblings. Clearly, the parent does not want to do that, and they're being pressured by the child. So, in cases like that, we do report those situations to the VPD. There's also the public guardian trustee. I mean, their job is to protect and advocate on behalf of minors, elderly, and people that lack capacity. So you could also report this to the public guardian trustee. As POA, if you have the POA, do you have this power to legally remove the son? Possibly. I think it would be worth an application to court. I think that a representation agreement might be the more appropriate legal document for this. So a POA is limited to legal and financial affairs, people's property. So when you ask a lawyer to make a POA for your elderly parent, you're doing it so that you can manage their bank accounts, their investments, their house. You can file their taxes. You can make sure they're receiving their social benefits, their government benefits, they're paying their cell phone bills, and so on. You're just managing all of their property. But when you want to care for a person's, your parent's person, their health, their well-being, their living arrangement, that would be what's called a representation agreement. It's a separate document under a separate law called the Representation Agreement Act. And that allows you, it gives you the legal authority over their health care. So you could discuss their health with their doctors. You could fill their prescriptions. You could determine if they're fit to live on their own or if they have to move to a care facility. And if they do move to a care facility, you'll be able to give instructions to the staff there for medications and quality of life. You'll be able to determine where they live, who they live with, who they associate with. You could get a restraining order against somebody that you think might be committing elder abuse, as is common in society. And and you can also make end of life decision making with a representation agreement. You can allow for surgery, decline surgery, or pull the plug, so to speak, if it comes to that. So if you only had POA, I would still think you could probably apply to court. You would need evidence of abuse. It would be a big ask to have a son legally removed from the house. So you would need evidence of abuse. It can't just be a suspicion of abuse. But I would hope that you also had a representation agreement. That would be, I think, the more appropriate document for this situation.
Excellent. Thank you so much, Jeremy. Moving on to our next question. My father recently passed away. My mother is the executrix and beneficiary of his will. The problem is that she's 87 and has dementia. I'm the next named executor in my father's will. How do I step in as the executor?
Okay, so this is an easy situation to be in. It happens quite a bit. Even when I make wills, I always name the parents as each other's first executor, and then the children as the second backup executor. And I explained that it is very easy to renounce an appointment. So when you're named as an executor in the will, you're not roped in any way. There's no legal requirements on your part. When the time comes that the testator, the person who made the will, passes away, you then have the option to accept the appointment and become the executor, or to renounce the appointment so that we then move on to the next person in line. The renouncement is a very simple one-page document that needs to be signed and witnessed, but it does not need to be notarized, so anybody can sign it. Anybody can witness it. If somebody has dementia, then again, we go back to that question, where are they on the spectrum of dementia? If they're able to understand what they're doing, which is just renouncing the appointment, then they can go ahead and sign it and anybody can witness it. If they're too far gone to understand what this is, if there's a power of attorney for them, then again, this is a legal matter. The power of attorney can sign the renunciation on their behalf, even if that person is the daughter, the same person here who wants to step in as executor. And in the event that there's no power of attorney and the mother is not simply able to sign the renunciation, a probate application has a section where you can explain if there's a prior executor who is still alive and who hasn't renounced, but yet they're not applying to be the executor of the will. And you can just explain why in that application. And you could even include supporting documents like medical records showing the diagnosis of dementia so that you could then go ahead and apply yourself as the backup executor for the will. So this wouldn't be a problem. It's nothing to stress about.
Excellent. So in making that application then through the probate process, it would be the daughter as the sort of next in line executor,
Right.
explaining why the first in line executor is not taking on that role.
Yeah. In the event that the mom is not able to sign that one-page renunciation, that would be the worst case scenario, but it's not a problem at all.
Excellent. Thank you so much, Jeremy. Um, Moving on to our next question. In this case, my sister named me as an alternate executor in her will, and she is now in a care home with dementia. How can I resign effective immediately? Her daughter wants to take my place. How does that work?
Okay, so again, you can sign the renunciation. You could do it preemptively. Normally, these things are done once the person passes away and it's time for the executor to either accept the appointment or renounce it. But you can sign a renunciation in advance and just send it to whoever's holding the original will. Just keep it with the original will. At that point, you're no longer in the order of priority. Obviously, there's going to be a first executor, executrix. But whether you're the first or the alternate, if you sign the renunciation in advance of death, then you're just never going to be tapped to assume that responsibility. So as for the daughter wanting to take the place, there's no way to do that in advance because the mom has dementia. Let's assume that she's not able to sign a codicil to her will, naming an alternate executor. So again, when the person passes away, when the sister passes away, um, if there's nobody available to be the executor of the will, then as we discussed before, the daughter can apply under WESA to become the administrator of the will, and then she will have all the powers of the executor. And if there are other beneficiaries of the will, then they would have to nominate her or approve of her application. And then the daughter will simply become the administrator. So what I would say to the daughter is just wait. There's nothing for us to do now, but let the other beneficiaries know that when the time comes, you will apply to be the administrator of the estate.
Excellent. Thank you so much, Jeremy.
Sure.
So In our next question, my dad named his wife as first executrix, and me as second. He died recently. His wife is in the early stages of Alzheimer's and doesn't want to be the executrix. How can she make me the first executrix?
Yeah, so if the wife is in the early stages of Alzheimer's, then I'm going to assume that she has the capacity to sign the renunciation, because again, it's a very simple document. She would just sign the renunciation, and then I guess the daughter would automatically become the next executor of the estate. So it's a very simple thing to do.
Thank you. And this is our last prepared question, and then we'll turn to the Q&A that are coming in from our guests today. My sister is the executrix of my father's estate. She also has power of attorney over the affairs of my mother, who has dementia and lives in long-term care. My sister has taken total control of everything and won't speak to me. How can I be sure that she's keeping proper records and accounts and that she doesn't keep all the assets or make poor financial decisions?
So again, a very common scenario. And I always encourage clients to name all their kids as powers of attorney. But it's very common for people to say, well, there's one son that I don't trust, or my daughter lives in Australia. So I would say that it's quite common that parents will name just one child and not the others to be their POA and their executor. They'll often try to choose what they think is the most responsible one or the one for whom it's less of an impact, I guess, less of an inconvenience. Um, in this case, um, a power of attorney does not, in fact, a power of attorney is not even allowed, really, legally allowed to disclose financial information to third parties, which would include other children of the parents. It's considered confidential information. So a power of attorney has a legal obligation to keep a lot of the finances confidential. In real life, it would be nice if the sister would just show the bank accounts to her siblings, knowing that they're going to be beneficiaries under the estate, and just for full disclosure, and there's nothing to worry about. But sometimes that doesn't happen, and it doesn't automatically mean it's a sign of fraud. It could just be that the power of attorneys, following the law to the letter of the law and not disclosing anything. So, what resources does the sister have to ensure that her POA sister is not taking advantage? The only resource available to you is to file a complaint with the public guardian and trustee. They have the legal right to investigate, to ask for bank statements, financial records. They will interview the POA and ask questions. That information will not be released to the person who's filing the complaint. Everything happens in-house at the PGD. It's confidential. And whether or not the public guardian trustee decides to investigate will be based on the complaint that was filed. If you're just going to say that my sister has control over everything, she's not showing me anything, I don't trust her, can you investigate? I don't think the public guardian trustee is going to do it. They're stressed for resources. It's taking 8 to 9 months at this point for me to get information back from the public guardian trustee when I probate wills for people whom they were caring for, because there was no power of attorney in effect. So I just think that from a resource management point of view, they're not going to be able to follow up on every single complaint. So if they do follow up, great. If they don't, the only recourse you will have left is that when the parents pass away and then everything gets transferred into the estate, at that point, you have the right to see all the finances of the estate. Will you have the right to see bank statements going back in time for years? I don't know. Depends on the circumstances, I guess, and what evidence you have to demand that. But you will ultimately get to see where the estate is at once your parents pass away. And if it more or less matches what you expected your parents had, then there probably wasn't anything inappropriate. On the other hand, if it's substantially less than what you were expecting, which happens, then you have the grounds to demand an accounting from her in her capacity as POA. And if she doesn't do that, then speak to a lawyer because we can make a demand on a POA for that. Again, a POA is a fiduciary. So they have the requirement to keep all financial records, a diary of all their transactions. Unless the POA allows it, they're not allowed to reimburse themselves for their time. They're allowed to reimburse themselves for expenses, but they need to have receipts for those expenses. and they will not be given the benefit of the doubt if they go to court and say, look, Your Honor, my mom made me the POA. I'm not an accountant. I'm not a lawyer. I didn't keep records of everything. I'm sorry. Can we be real about this? The judge will not listen to that kind of an argument. If you want to be somebody's POA, you have to understand and accept it's a fiduciary responsibility. So you do have to live up to the standards expected of you under the law, which is quite high.
Excellent. Thank you so much, Jeremy.
Sure.
You've been so efficient in answering our questions. We've got quite a bit of time for the questions that have come in from our guests. And thank you, everybody, for submitting your questions. I can see there's some really great ones here. So what I'm going to do is I'm going to ask questions in the order that I think is probably the most relevant to the topic, and also looking at the number of upvotes. So Jeremy, here's our first question. How can one initiate an assessment of a person with progressing dementia to see if the person is really able to stay alone in their home or should be placed into a facility to receive proper oversight and care? That's the first question. I'm not sure if that's a lawyer question or
Yeah,
more.
I know that Vancouver Coastal Health has mental health care social workers whose job it is to go to people's homes and do a home assessment. They will determine if what the person's capacities are. They will determine if they're physically able to live in the home, like if there are stairs in the home. You can get those motorized seats that go up and down stairs. I've seen that many times. Are they able to use the facilities and the stove? Are they able to call for help when they need it? Are they able to get up if they fall down? So that would be more of a Vancouver Coastal Health mental health care workers assessment. It's not really a lawyer's place to say if a person is able to live at home or not on their own. So,
And this might be a related question then. What happens if someone needs to go into memory care? I'm not sure if memory care is a type of care, or if what they're have in mind is like long-term care. But they are resistant to going, and there's no power of attorney or committeeship yet.
yeah, then again, and this is what I explain to clients, the importance of getting a representation agreement. If you don't get a representation agreement where you provide that authority to, let's say, your children, your siblings, your friends, to make the decision when the time comes that you're no longer fit to live on your own, you need to be forced to move to a care facility. If you don't want to give that authority to a family member or a friend, the government's going to be the one that makes that decision for you. They're going to send a social worker, and when that person decides that you're no longer able to live on your own, they are tasked with finding solutions to allow you to live at home as much as possible. They will recommend solutions to make it possible. But when it comes to a point where you can no longer be on your own anymore, the social worker will write a report determining that you're no longer fit to live on your own. And at that point, you have to be moved to a care facility. And yeah, there are situations where elderly people have to be forced to do it against their will. Yeah.
Jeremy, there's a question here that seems, again, to be related along this theme. Uh, if there's no representation agreement either, like say, for example, the person with dementia ends up in the hospital and the family members are unable to care for them at their home, do they just get kept at the hospital? Would the hospital be able to send them into a care facility?
I would expect the hospital sends them to a care facility. Hospitals are not long-term facilities. Once they solve the issue, they're going to want to free up that bed. But if they determine that they're not fit to go back home, that you haven't set up the resources that this patient needs, then yeah, I would expect them to provide, again, a social worker to assist you in finding a long-term care facility for them.
Excellent, thank you.
Yeah.
This next
Uh,
question is,
and just,
oh
I
yeah,
should say as well that as to where what I said before with the power of attorney, that spouses or children have no capacity whatsoever to access each other's personal property, bank accounts, real property, anything like that. Um, Family members can make healthcare decisions on each other's behalf without a representation agreement in limited circumstances. If there's a car accident and there's an emergency and somebody needs surgery, but perhaps there are risks involved and the doctors need a disclaimer to be signed, or just consent to be provided for the surgery. Next of kin is allowed to do that. The law allows that. So usually it would be a spouse or an adult child is first in line, then your parents, then your siblings, then grandparents, and whatever family member can present themselves will be authorized by law to make those healthcare decisions. So for end of life decisions as well, if somebody has a terrible accident and they're in a coma, they're in the hospital, they're on life support, and the doctors as a team have determined that there's no chance of waking up. You're brain dead, your body's being kept alive by artificial means, and you're not going to wake up. Doctors need consent to pull the plug. They're not allowed to pull the plug on their own. So the closest next of kin is authorized by law to make that decision, and they will have to make that decision, and a social worker will be provided to encourage you to pull the plug, essentially, because hospitals don't have the resources to keep people alive indefinitely in those situations. So, as to where you absolutely need a power of attorney for legal and financial affairs, there are certain circumstances, certain decisions that can be made for loved ones without a representation agreement, but only for family. It won't extend to friends.
Thank you so much, Jeremy. Um, Here's another question that has come in. Can representation 7 for finances be completed for someone with mid-advanced dementia? And maybe if you would let us know what representation 7 for finances.
Yeah, so there's two representation agreements, Section 7 and Section 9. Uh, a Section 7 is like a watered down power of attorney and a watered down representation agreement. It provides limited powers for the candidate um, for either managing property or managing your health. It's kind of watered down. What's much better and what I always recommend is getting a proper power of attorney and a Section 9 representation agreement. And everything I've been describing about representation agreements is a Section 9, what's called an enhanced representation agreement. And that covers all healthcare needs from very small things like filling prescriptions to very powerful remedies like allowing or declining surgery and committing parents to a care home and so on. And in terms of being able to enter into a Section 7 rep agreement or a Section 9 or a power of attorney, the standard of capacity is going to be similar in all those situations. And when you to say that, well, somebody has mild dementia, whatever the wording was, mild advanced dementia, again, bring your parent to a lawyer, let them sit down with them to assess them. Something that lawyers often do in situations where somebody's borderline and we want just a little bit more evidence of capacity under the circumstances to back us up in case somebody out there were to challenge these documents down the line, is that we can often ask the family to get a letter from their GP confirming that they understand what they're doing. They understand the nature of a rep agreement, a power of attorney, a will. I have a template letter that I can email clients. It actually explains to the doctor what is the definition of understanding a will, testamentary capacity, what is the definition of understanding a power of attorney, the nature and consequences of the document, and a rep agreement. And then it is a statutory declaration that the doctors can sign saying, I've been so and so's GP for X number of years. And in my opinion, in my medical opinion, they have the capacity to understand the nature and purpose of these documents. They'll sign it. And then lawyers can have that in their file. It'll encourage us to go ahead and prepare these documents. Keep in mind that as lawyers, we're here to help people deal with difficult situations. My father's 97 years old. He has advanced dementia. He became a rabid gambler in his 90s, and I had to go to court and get a court order stopping him from accessing his bank accounts and to stop him from gambling. So I have personal experience with this as well as with all my clients. So we're here to try to help people, when they obviously need help. It would only be in situations where people really have lost all capacity, and even their doctors are not willing to entertain the idea that they might be understanding these documents. And even then, you still have options like applying to court to be named somebody's committee. So, yeah.
Thank you so much, Jeremy. And on that note, uh, thank you for sharing that with us, and thank you for answering all these questions so completely and helpfully.
My pleasure.
Just wanted to say you're doing a great job, and thank you to everybody for submitting your questions. It's really wonderful to have these really great questions to bring to Jeremy. This next question, Jeremy, I think it's in response to a thread. I'm not sure what the initial thread is, but I think it ties in again to this representation agreement under Section 7, and the relationship between applying for a committeeship. So the comment is, I thought an RA7 would come before a committeeship. So would you mind just clarifying the relationship between those two steps or those two processes?
The committeeship is there if it's too late for somebody to enter into an R7 or an R9 or a power of attorney. So if you already have a Section 7 representation agreement and it's validly done and all that, I don't think you would need a committeeship, but there are inherent limitations in an R7. So if you needed to do something that couldn't be done with the R7, then your only other option left would be applying for a committeeship. So in that sense, yeah, the question is valid. But one would hope that if you got your documents in order, you would not need a committeeship. Yeah.
Excellent, thank you. Um, does a stepdaughter have the same rights as a true paternal child in disputing a will or trying to commit the stepparent with dementia? There is no power of attorney.
No, step kids have no rights. It's the rights to challenge a will is limited um, to legal spouses and common law spouses and to biological and adopted children. It does not extend to stepchildren. And that sort of branches out into the whole complexities around estate planning for blended families. This is one of the biggest areas of litigation, to be honest, because when parents just make wills leaving everything to each other, and then upon the last of them to pass, everything goes to the children, but only one of them has children. If it's the step parent that survives, that step parent can change their will after the fact to leave everything to whoever they want, disinheriting the child of their deceased spouse. And that child has no recourse against the step parent. So that's where people need legal advice. We could craft your estate planning in a way that you can still benefit each other. The spouses can still benefit each other so that you have your quality of life, but in a way that ensures that your children will ultimately have the legal right to that estate, be it from your biological parents or your step parents. It's a bit more involved, it's a bit more complex, but obviously it can be done. But otherwise, stepkids have no rights against step parents' estate. Yeah. And they can apply for a committeeship. Anybody can apply for a committeeship. You just have to be supported by whatever family members are still alive. If there are no family members left and this is your step parent, then yeah, you would be the natural person to apply to be committee. And I think a judge would understand that.
Excellent. Thank you so much, Jeremy. We've got a few more minutes, so I'm going to keep asking you questions. You're doing very well, and thank you
Sure.
again to everyone for submitting these questions. And I'm choosing the questions, as I mentioned, I'm trying to focus on the ones that are most uh, closely aligned with the topic. So we've talked about committeeships. How long does it typically take to get a committeeship? Should the first step be with the physicians or with a lawyer?
First step should be with a lawyer because the lawyer will actually be the one to instruct the physician about what we need. Lawyers' notes, for example, are not admissible in court. They have to prepare special reports that are admissible in court. So I would suggest meeting with a lawyer first and the lawyer will also help you understand the kind of a case that we have. We don't want to apply for committeeship if we're not going to be successful. So the lawyer will explain to you what the requirements are for the application. And in terms of time frame, it varies. If it's an emergency, we can always appear in front of a judge within 48 hours if necessary. If there's surgery that's needed or a life or death kind of situation. Otherwise, it probably would take a few months. So yeah.
Excellent, thank you. Jeremy, you mentioned while we were going through the initial questions, situations where you've got a power of attorney and there's multiple persons who have the powers who don't necessarily agree on what needs to happen. So the question here is, what if a joint, and I think it says EPOA. I'm not sure if that's a thing.
Enduring power of attorney.
Enduring,
Yeah.
thank you. Okay, there we go. What if a joint enduring power of attorney who must act together don't agree at all? What can you do?
Okay, good question. So I've had that situation not only with POAs, but also with beneficiaries under a will arguing like crazy, with the trustee not knowing what to do and contacting me for legal advice. So, if when you're acting in a legal capacity and you're in a conflict situation, you need a dispute resolution mechanism. So you can do anything from appointing a third party to act as an unofficial mediator. It could be a friend, or it could be a lawyer. I've had in that situation where the beneficiaries were arguing, there were three of them, and they all agreed to meet with me together and air their grievances. And I made a recommendation, and they agreed just to follow that in the end. So try to come up with a third party that can mediate, so to speak. Because the alternative is that you guys both end up getting lawyers, and lawyers will always end up duking it out and aggravating the situation. So try to find an unofficial mediator, and also to give you advice. Maybe one of you is in the wrong and one of you is in the right, and so and you just don't have the knowledge to understand that. So maybe just get a consultation with a lawyer, and it can be paid for by the estate if you're acting in your capacity as a POA or as a trustee, and get that legal advice. And if it means that both your positions are valid, it's just a question of yay or nay. Then yeah, you guys can agree to appoint a third party mediator, and whatever decision is made, you guys will agree to. It doesn't have to be binding, but you'll agree to it.
Excellent, thank you. Um, I think we have time for one more question, Jeremy.
Sure.
So this is a question, and again, thank you everyone for your questions. They're really great. Our children live overseas and are not eligible for powers of attorney or executors. Is our only recourse a lawyer to fill this role? We don't really have any other backups as our friends are also failing.
So living abroad does not invalidate the role of being an executor or a power of attorney. You can appoint foreign children or spouses or anybody to be your executor or your POA. There's no residency requirement to act in those capacities. There are tax implications to having a foreign trustee, executor, or a foreign power of attorney. Those tax implications may or may not manifest themselves. It depends on the nature of your assets and the situation. So I often, when clients are in this situation and they say to me they have nobody local they can appoint, and their son is in New York and their daughter's in California, if there's really nobody else to appoint, then yeah, just appoint your son and daughter. And if there are tax consequences, then they'll deal with it. They'll just pay the taxes and that's it. Um, so you can appoint them. As far as appointing lawyers to or anybody else, I mean, ideally you can appoint a friend, a niece or a nephew. Sometimes friends will appoint each other to be executors of their wills and POA, so they're kind of taking care of each other. But if there's really nobody else that you can think of, then yeah, lawyers are available to act as trustees. There's also institutional trustees. TD Canada Trust, will act as trustee, but they're very expensive, to be honest. Lawyers will probably also be expensive, but yeah, lawyers are available as a last resort. But like I said, you can appoint a non-resident person to be your trustee, your executor, your power of attorney, your representative under representation agreement. That's okay.
Amazing. Jeremy, thank you so much. This has been such a great webinar. You've done such a great job of answering all of the questions that we prepared in advance, as well as a good number of questions that came in from our guests today. So a big thank you to you. Is there anything upon reflection? I mean, you've answered dozens and dozens of questions. Anything that you wanted to add or highlight before we sign off today?
Well, I guess one thing I would say is that People's Law School is a fantastic resource for information. I've used it sometimes when online researching for stuff. So it's fantastic to see this from this point of view, just the content creation point of view, I guess. But it is a fantastic resource. So thank you, Paula, and the team for putting this on for everybody. And I guess the only other thing is that, for the people out there, if you are caring for elderly parents or for a sibling, or you see it coming down the line, don't wait until it's too late. Reach out, just an inquiry. I offer free consultations. A lot of lawyers do. You can at least get the knowledge that you need so as to plan in advance. Applying for committeeships, which is a whole court application, it's expensive, it's stressful. That's only there for people who haven't planned in advance. And when the public guardian trustee has to take over somebody's person or their property, again, it's only because they didn't plan for it in advance. So the time to do it is, in advance. And then once the documents are done, they can be filed away and you just forget about them until the time comes.
Thank you so much, Jeremy. It's such wise words, such wise words, and something that we all need to prioritize. So thank you so much, and thank you again for your kind feedback, and for joining us here today. So with that, we're going to say goodbye and wish you all a really excellent rest of your week.